The matter before us is Parkview versus Nader. Each side will have 15 minutes, and the appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve any time, please let me know, and I'll give you a signal when you have run out of your rebuttal time. You may proceed.
Good morning. On behalf of the appellants Ruth Nader and Malika Boud, my name is Michael Ayton. I request to reserve 3 minutes of my time for rebuttal.
All right. You may proceed when you're ready.
Okay, in brief, the appellants asserted 6 assignments of error. I'll be addressing each of them in turn. First, as to the jury demand, this is a pretty straightforward matter. An action for personal judgment for monetary damages on the note is an action at law. There's plainly a right to a jury. This is different from the scenario posed by some of the case law that the trial court relied upon in making its contrary finding, where the only claim for damages is upon a deficiency after the sale of collateral. And this is not an all or nothing proposition where it's a judgment call that this is predominantly a foreclosure action and therefore you don't have the right to a jury on anything. It's fairly simple as to a standard 2-count foreclosure. It's simply a matter of some issues, specifically personal liability for, and the amount owed on the note are jury questions, and others, such as the equitable right to foreclosure, are not. Second, and again, this is where I anticipate spending most of my time, as to the motion in limine excluding evidence prior to the loan modification and assumption agreements that were signed by Ruth Nader. These agreements are substantively as well as procedurally unconscionable, and as such, they factually open the door to events occurring before and relating to the balances prior to the entry by the parties into these agreements. First, the agreements purport to modify the terms of the note and the line of credit without being executed by Elia Boud, while at the same time still holding him liable under the same. This goes as briefed against the provisions of the UCC governing negotiable instruments, as well as basic contract principles, and again also as cited from deposition testimony, the policies and procedures of Parkview itself. These agreements effectuated the assumption of a combined $1.5 million in loans by Ruth S. Nader, who at that time had an income of about $400 per week. Okay, these are clearly not bona fide modification and assumption agreements. Rather, instead, they were plainly motivated by the need to preempt any challenges to the amounts owed by obtaining Ruth's assent. She was simply in no position to do so, as Parkview, primarily by and through its chairman, Jack Mayle, were aware. All of the Aboud's business was handled through Ruth's husband, ex-husband now, Ely, who at the time of the assumption modification agreements was conveniently unavailable. Additionally, at the time, Ruth was under duress. She was essentially faced with the proposition, you sign these or we're going to take your house. The fact of the matter is, as to the underlying balance on the line of credit, there was never any agreement to exceed the limit on the line of credit by charging the amount owed for the payment of the letter of credit to the line, which at that time was already maxed out. And the assumption and modification agreement as to the line of credit was simply an attempt to get Ruth to basically ratify this transaction after the fact. Additionally, on the counterclaim, per the law cited in brief, it's an abuse of discretion not to permit compulsory counterclaims, as they could not be asserted in a separate action. There is, in fact, such an action currently pending, and based upon the compulsory nature of the counterclaims in this matter, Ruth was stopped from asserting these claims against First National Bank of Pennsylvania, Parkview's successor here. Additionally, even if we assume the preclusive effect of the assumption and modification agreements as to the balances that extant on the note and the line of credit, and we also assume the propriety of the trial court's decision not to permit her to reinstate her counterclaims, which is uncontroverted, were dismissed by her attorney without There is still the issue of the recoupment defense of the proceeds from the sale of stock that were never accounted for, which, again, even finding no error in the exclusion of evidence prior to the assumption of modification agreements, and not permitting the counterclaims as affirmative relief, there is still the matter of set-off and recoupment. Fourth, the motion of Malik Abood to rejoin Eli Abood as an indispensable party should be granted. It was essentially conceded by the appellee that Eli Abood was an essential party herein when it sought to join him to the action in the first place. However, once the issues as to the assumption and modification agreements, as well as the pre-acceleration notices that were not sent to Eli arose, a tactical dismissal of Eli as a party was simply effected in hopes of skirting this issue voluntarily and without needing to obtain stipulation of parties or the court's leave. Eli was simply out, and the issues were treated as being out also. Finally, as to the motion for summary judgment, the acceleration clauses in the note and line of credit do provide that notices to be given to all borrowers as a condition precedent to the initiation of this action. There is no evidence of record that any such notice was ever sent to Eli Abood. Quite frankly, there are any number of factual issues that should have precluded summary judgment in this case, and which did the first time that an identical motion for summary judgment was filed and opposed in the trial court. The court recognized that there were issues that needed to be litigated, but as is palpable from the court as speaking through its orders, once the case got to a certain point, the trial court simply decided that it was done with the action. So on the same record upon which it had found previously genuine issues of material fact, it decided that there no longer were any. And this reached a point where even upon entering the final decree of foreclosure, which in the interests of expediency and getting the merits of this appeal heard as quickly as possible, the appellants tried to point out to the trial court it was defective in its failure to account for the priorities and amounts of other liens that were due and owing. The trial court, of course, overruled this motion the very day it was filed without waiting for opposition. Lo and behold, fortunately, because the appellants had filed an earlier appeal of this case, the issue was brought to the attention of the Ninth District, which found you do in fact have a problem, there is no final order. Had these been the delaying tactics that the trial court plainly regarded them to be, we simply could have waited for a sale to go forward on the defective decree, appealed the confirmation to wait to wind everything back, and we wouldn't be here on the merits for another few months yet. I would stand at this point. Thank you.
Good morning, or maybe afternoon by this point. May it please the court, Rich Klein with McDonough Hopkins on behalf of the appellee First National Bank of Pennsylvania, which is a successor by merger of the Parkview Federal Savings Bank. With me here today is Chuck Edwards of Parkview Federal Savings Bank, which is now First National Bank of Pennsylvania. At its core, this case is a simple foreclosure action. There's been a failure to pay anything on the underlying note and underlying debt since 2011. Based on those defaults, the bank initiated a foreclosure action. Now, 5 years later, the borrowers still own and reside on the property as a result of numerous meritless arguments and claims. And we are here today to finally put an end to this. There are 6 assignments of error listed in the appellant's brief. It's somewhat difficult to decipher which arguments are attributed to each. The appellant's facts section is devoid of any reference to the record at all, and is simply a recitation of prior pleadings. Nevertheless, I will address each assignment of error with the arguments that I believe that are being posited by the appellants. First, the appellants claim that the trial court abused its discretion in denying the appellant's jury demand. This is, as this court is well aware, obviously it's more than just an error of judgment. It must be unreasonable and arbitrary and unconscionable. The trial court was clearly correct in denying appellant's jury demand. A right to jury demand does not exist if the relief sought is equitable rather than legal, and that's long-standing case law. Taylor v. Brown is Ohio Supreme Court's case from 1915. There are other cases cited in my brief as well. If there is a mixture of legal and equitable issues, the right to a jury depends on the action's primary and predominant objective. Now, there are numerous cases cited in my brief on this issue, but I think the one that the court should focus on is one directly on point, and that's the National City Bank versus the Abdallah case. In that case, we've got a promissory note with a mortgage. There was a default. A complaint was filed for $300,000 and foreclosure. The defendants filed a counterclaim saying that there was some changes to the note. The Court of Appeals upheld the trial court's denial of a jury trial, even though the counterclaims did change the overall nature of the action. The overall nature of the action was an equitable action. And this was on the counterclaims of the defendants in that case. And that's just like the case here. The overall nature here is equitable, so there's no right to a jury trial. But the other thing is this issue is also moot because the trial court granted summary judgment. So that issue is moot. The appellants waived the right to appeal this issue as well because they failed to file a motion to set aside the magistrate's order as required, and this was noted in the trial court in its order. This assignment of error should be overruled. Second, the appellants claim that the trial court abused its discretion in granting First National Bank's motion to eliminate based on the parole evidence rule. It's a little hard to determine in the brief what arguments are being presented to support this parole evidence issue, but I will tell you that this case presents a textbook way of describing what the parole evidence rule is and why it's in effect. Here are the critical facts. You have Ruth Nader and Eli Abood. They execute a note and a credit line and sign mortgages. In 2008, 10 years later, because the other one was 1998, Ruth Nader, as the individual and as the trustee of the trust, which is now the owner of the property, she signs an assumption and modification agreement on both the promissory note and the credit line on what is owed. These agreements continue the obligations of Ruth Nader. They assume the obligations of the trust, assumes the obligations, because now the trust is the owner of the property. It also reduces the interest rate. It has lower monthly payments. It's a page-and-a-half document. Malik Abood signs the guarantee on the credit line saying, here's how much is owed at this time. And that's what the modification assumptions do. They say, what is owed at this time? And this is in 2008. They made 40 payments after that. Then years later, in this lawsuit, Ruth Nader and Malik Abood argue that the figures that were listed in the 2008 modification agreements, those aren't right. Prior to 2008, back in 2002, there were some issues that should affect what the amount was. So now they're arguing that the amounts that they signed in 2008, you have to go back prior to 2008, prior to the modification agreements being signed. And this is exactly why the parole evidence rule exists. This is how you would teach the parole evidence rule. You could use this case as an example of why you have the parole evidence rule in effect. It prevents a party from introducing this evidence prior to the signing and execution of a document saying, here's how much is owed, and then years later you say, well, that wasn't really the case. They made payments, 40 payments after these notes were signed. They've waived any argument that these amounts are not owed. Third, the appellants argue that the trial court abused its discretion in denying the motion for leave to reinstate the counterclaims. Now, the appellants did file counterclaims in this case. They filed them in August of 2011. There was extensive discovery that took place for 3 years while these counterclaims existed. First National Bank filed a motion for summary judgment, and in response to the summary judgment, they dismissed their counterclaims in April of 2014. Then a motion to eliminate was filed, the one we just talked about here on the parole evidence rule, in February of 2015, and it was later granted that month. Then the appellants asked, a year later after they dismissed it, can we reinstate our counterclaims? Because now they realize that the parole evidence ruling is going to have an adverse effect on their claim. The trial court was clearly right in denying this. It was 4 years after they had initiated the counterclaims. They had been pending for 3 years. It had been dismissed for a year, and now they want to reinstate them simply because there was an adverse ruling. The trial court was completely right on that. and they recognized that it was too late. There was no legally sufficient justifiable reason to allow the appellants to refile their counterclaims, given the facts of this case. They failed to comply with Rule 13F. They're bound by their actions. Now, you've heard the appellants say that these counterclaims were dismissed by their prior counsel without their approval. Well, they have a legal malpractice action against that prior attorney. They can simply go after him. And interestingly, he said in that case that the Aboods had no claims against First National Bank. Fourth, the appellant Malik Abood asserts that the trial court abused its discretion in denying their motion to join Eli Abood as an indispensable party. Now, Malik Abood is liable here based on an unconditional continuing guarantee agreement. Mr. Abood mistakenly believes that judgment must be rendered against Eli Abood before his obligations become due. And that's just simply not the case. The guarantee is clear and it provides, and I quote, "The obligations of the guarantor hereunder are independent of the obligations of the borrower, and a separate action or actions may be brought against the guarantor whether or not action is brought against the borrower, and whether or not the borrower was adjoined in any such action." That's standard guarantee language. First National Bank can go after one, but not all the borrowers, because a similar issue was set forth, a similar provision is set forth in the promissory note and the credit line. They may seek judgment against the guarantor independent of the borrower. Now, Malik Abood can certainly initiate, to the extent he's found liable in the guarantee, he can initiate an action against Eli Abood for a contribution. But there's no abuse of discretion for the trial court in denying their motion for leave. Finally, the appellant's fifth and sixth assignments of error are kind of interrelated. They argue that the trial court improperly granted summary judgment and that they issued a decree of foreclosure improperly. And it appears as though their arguments are threefold. One, that there were certain conditions precedent that were not met for the acceleration of the note and credit line. Two, that the assumption and modification agreements are unconscionable in some way. And then three, that there's a dispute on the amounts due and owing under the note and credit line. None of those arguments have any merit. First, the appellants seem to contend that the letter of default was not sent to, because it was not sent directly to Eli, the debt can't be accelerated against Ruth Abood and the trust. And that's simply not the case. Notice of default was given to Ruth Abood in October of 2010, individually and as the trustee of the Almost Heaven Irrevocable Trust. The debt was accelerated against her and the trust. Judgment was rendered against her and the trust. Judgment has not been rendered against Eli. The note and the credit line explicitly permit First National Bank to seek judgment against each of the borrowers independently. They don't need to seek the judgment against all of the borrowers. That's standard language in these notes. Second, the appellants argue that the assumption modification agreements are unconscionable or commercially unreasonable. There was no evidence whatsoever presented to suggest that these documents and these agreements are unconscionable in any way. They're 1.5-page documents. The trust assumed the debt, the interest rate was lowered, the monthly payment was lowered, and it was a recitation of here's how much is owed. Ruth Nader, she's an attorney. This is a 1.5-page document. These agreements aren't unconscionable. What is unconscionable is the fact that FNB hasn't received any payment on these notes since 2011. Third, any dispute on the amount that's owed under the credit line and the promissory note, that's already been addressed. That was all dealt with in the parole evidence rule and the assumption of modification agreements. Also, the appellants failed to object to the proposed judgment entry and decree and foreclosure that was filed on November 25th, 2015. They failed to object to that in the trial court. They waived their right to challenge that. Despite all of appellants' motions and briefs and arguments and counterclaims that they filed and everything to the contrary, this case is nothing but a simple foreclosure matter. Money was loaned, a mortgage was filed, standard residential mortgage, lending. No payment has been made for 5 years, and not much was made for the years prior to that. But the appellants still reside in the house. All First National Bank is looking for is the benefit of their bargain. It's time for this case to be over. based on the reasons set forth in my brief, in the trial court and argument today, respectfully request this court to overrule all of appellant's assignments of error and affirm the trial court's judgment in its entirety. Thank you.
Thank you. And you have 3 minutes.
My colleague is of course right. This is a simple foreclosure. I would however posit that just because the fact of default is not an issue does not mean that the other issues involved here are not important. We're talking about approximately half of the combined balance on the note and line of credit that are subject to the issues that are being raised on appeal, which obviously has a great deal of an impact on the appellant's ability to affect the equity of redemption. So, I would admit Parkview has not been paid since 2011. I don't think that means that the issues raised herein are simple trivialities. I would agree that this is a textbook parole evidence case. However, it is the primary exception to the parole evidence rule for which this is a textbook case. Throughout my colleague's discussion of the issue, there was not a single mention of the fact that the agreement itself, on its face, purports to hold Eli Abood liable for the modified terms of the agreement. The agreement is not signed by Eli Abood. Parole evidence rule only applies when the 4 corners of the agreement itself unambiguously indicate what the agreement of the parties was. Was Eli or was Eli not liable for and subject to these modified terms? And again, it's correct. They don't need to seek a judgment against all borrowers. They can tactically dismiss Eli for any issues that actually are personal to him. However, as a negotiable instrument, the promissory note has to be for a sum certain. It can't be one amount as to Eli Abood by virtue of not being aware of, not being a party to these purported modification and assumption agreements, and a different amount altogether as to Ruth S. Nader, who was induced to sign them, and Malik Abood, who signed under an ongoing conditional guarantee. I thank the court.
Thank you. We will take the case under advisement and send you a copy of our opinion when it's issued. Thank you and have a good day.